There is a noting that I have not filed the certificate of surrender certificate. It was released on interim bail for already filed, taken up for verify and
Has he filed the surrender certificate? In fact?
yes, 2510.
You have
Yes.
that surrender certificate with you.
Is the receipt.
Okay. Tomorrow?
No, my lord, some of them, my eyes have been infected. That is why.
Well, let us see. Thursday. We'll see, because
No, my lord, 1 week after, because I have to contact the client. That is the reason.
This
Because
is
he is
24 matter.
Pardon me, Lord, item 28, my lord.
Yes.
It is jail criminal appeal.
Hmm.
And this honorable court directed me to file a fresh appeal and also delay condon petition, my lord. I have not filed, my lord, 2 weeks time, my lord.
22 weeks time.
28.
28. 1 minute, madam. Let one is over. Yes.
My lordship, in item 58, I am paying for short adjournment.
58.
Hearing.
25 matters. All right. Okay.
Item 31, my lord.
31.
I have been appointed by the High Court Legal Aid Committee, my lord. I have not received the brief. Your lordship, take up next week. I will get the brief and
You, huh? I'll accommodate you, but let it come then.
My lord.
Regular. Yes, madam. 35. I'll accommodate, but let us see what exactly has to be done. Let it come, then I'll accommodate. Don't do it. Yes.
Not mentioning that.
Yes. Start. Is he any mentioning? No. Okay.
Item 1.
Your Lordship, in item 1, Mr. Suraj Mahanti has prayed for a Passover, Your Lordship. in
Okay,
item
pass over. Yes.
Item 2.
Your Lordship, item 2 may it please, Your Lordship.
Yes.
Lordship, it's a vigilance matter, Your Lordship.
Yes.
The petitioner is praying for quashing of the entire proceedings, including Annexure 2, which is the charge sheet, and Annexure 3, by which the learned trial court has framed charges against the accused petitioner under Section 7 and 12 of the PC Act.
The charges have been framed.
Charges have been framed, Your Lordship. Herein, the accused petitioner has not been named in the FIR, Your Lordship. Further, he is a
But
private person.
If the charges have already been framed,
Yes, Your
you have to challenge that charge.
Yes, Your Lordship. I have challenged the entire proceedings, including the order framing charges, Your Lordship. The order
No,
framing.
See, against a order of framing of charges, you have to maintain a revision.
Yes, Your Lordship. I've also challenged the entire proceedings on the merits of the case.
After the charge is framed, a specific order is looming at large on your face of your this thing record, that you have to challenge that specifically.
Your Lordship.
But see, you have challenged, when have you filed this?
Your Lordship.
October 2025, when the charge was framed.
The charge was framed on by order dated 24/7/2025, Your Lordship.
Then you withdraw it, and I will give you liberty to raise all these points by filing a right on. Petitioner has essayed the entire criminal prosecution initiated against him in Cuttack Vigilance PS case number 16 of 2022.
Your Lordship, if I
The
may.
counsel for the petitioner submits that in the meantime, on when
24/7/2025, Your
in the
Lordship.
meantime, on 24/7/2025, charges against the petitioner has been framed under Section 7.
7 and 12 of the PC
7
Act,
and
Your Lord.
12 of PC Act, Prevention of Corruption Act, as amended up to date. In view of a specific charge being framed against the petitioner, the counsel for the petitioner seeks to withdraw the present petition to challenge the order of charge by filing a revision petition by taking all the grounds as has been taken. In
Your Lordship, if I may be
with the liberty, the present petition is disposed of.
Your Lordship, if I may be just, Your Lordship, may I be permitted to change the nature of the application, the present application itself from the CR?
I see there is a lot of registry, the clerical work will be involved. File it, copy paste.
Yes, sir.
How much time will you?
Yes,
will
sir.
it take?
Yes, sir.
Revision.
I'm much obliged, Lord.
Yes.
Item 3.
Yes.
Here in this application, the petitioner seeking for a direction to quash the FIR and the entire proceeding of Pahala PS case number such and such on the ground of compromise. The
What are the offences?
offences are 137, 2, 3032 and 87 of the BNS.
137, what is that?
Of BNS, my lord.
No.
Kidnapping for the abduction, my lord, and kidnapping from the lawful guardianship for the purpose of marriage. These are the offences. The victim has already been rescued and she is now.
It's a serious offense. Can it be quashed?
Yes, my lord, since it has already been compromised between the parties and the victim and the petitioner number 2 is in
Let us
one.
see, let us see. If we have compromised, that's a 303. What is that 303? Again. Yes, 3032. Yes, what do you say? Where are the affidavit? Nothing is there.
Yes, my lord, affidavit has already been filed and
Is it a joint petition?
yes, my lord.
Huh? Who is Rajat Sahu?
Rajat Sahu is the one of the co-accused person who happens
And
to be
who
the
is
husband of
Ganesh
the
Malik?
Ganesh Malik is the other co-accused person who happens to be the friend of the Rajat Kumar Sahu who held the petitioner and the victim to
Listen,
Then,
where is the informant victim? They are also not there. Your
on
picture-
the last occasion they were present and filed a affidavit to that effect.
No,
that
they
the
have to
matter
be
has-
there.
Yes, my lord, if your lordship so desire, then I can produce them tomorrow, my lord.
Then counsel for the petitioner submits that the parties have settled their dispute, and to that
And on the
effect,
last occasion-
affidavits have already been filed, but neither the accused petitioners nor the informant or victims are present in the court, so therefore no cognizance can be taken at this stage regarding the settlement, regarding the settlement. Leave the matter next week. Next week.
Filed by the victim.
Affidavit was-
Filed by the victim. Let the victim will present.
All of them has to be present. Victim, informant,
Yes,
accused, everybody has to be present.
Victim and accused person will remain present before this honorable court on the next day. But so far as the informant is concerned,
There is no but. See, if it is a settled between the parties,
Yes.
informant has to be there. Otherwise, he will challenge tomorrow.
yes, my lord.
Why informant can't come?
Because
Informant must be the mother.
yes, she is the mother and she
Then-
is a little bit dissatisfied with my marriage.
Oh,
For
you
that reason,
make her satisfied in between. 1 week time I'm giving. But so it's very difficult. The informant is not there because at his instance or her instance, the entire criminal prosecution has been initiated.
But since the victim is not supporting the case of the prosecution, my lord, ultimately it is not going.
That is a different consequence altogether.
Yes, my
For
lord.
quashing purpose, I'm saying.
Yes, my lord.
If she will, in 164 and all, she will not support, then eventually you will acquitted or charge will not be framed.
I've also filed the statement recorded under section 164 CRPC, my lord, where the victim has categorically stated.
Then
then
on merit you can succeed, not on the ground of settlement.
Yes,
Merit,
yes,
you have a case, you argue
yes.
on merit,
Yes, my lord. Yes.
argue on merits.
Okay.
But if the moment you say settlement,
Yes, my lord.
then the informant has to be here.
Yes.
Next week, let us try.
Okay. Yes. my
Yes.
lord. Yes. On the last occasion, the Learned State Council has also directed to produce the up to date instruction from the police as to stage of the investigation.
Yes.
You can call.
In the meantime, the counsel for the state to obtain instruction regarding the status of investigation.
No problem, sir.
Yes.
Item 4, may I please? Lordship, kindly see the order dated 9/10/2025, ma'am.
9/10, huh?
My lord. Lordship direct to State Council obtain instruction, my lord. Other final. form-
Item 4, this is item 4.
My lord. Final form, my lord,
Bookso is there.
no,
No, there is no order of 9/10.
next week direct to State Council.
This is the
Final 4 ବର୍ଷ ହେଇଗଲାଣି
Matthew
investigation.
Krishna Raut.
My lord.
You referred to some order. Where is that order?
12/11/2000.
12/11, yes.
My lord. 12/11/2020.
The prayer of Learned Counsel for the state is granted this time to obtain instruction in the matter. What instruction?
Till date, my lord, final form is not submitted by the investigator. 4 years completed, my lord. Only allegation, my lord, a petitioner is
What
a
are the offences?
offense, my lord, 67,
Oh.
67A and 12 Poxo Act, my lord.
12 boxer.
My lord, allegation against the present petitioner is a physics teacher, my lord. In the time of COVID, the physics class going on, some my lord, pornographic people, 2 minute ପାଇଁ ଗୋଟେ ଖରାପ picture ଆସିଲା।
While he was teaching.
ଆଙ୍କ ଆଇଡ୍ରୁ ଆସିଲା ଯେ ଯେତେବେଳେ କ୍ଲାସ ଚାଲୁଥିଲା ଆଙ୍କ ଆଇଡ୍ରୁ ଗୋଟେ ଖରାପ ପିକ୍ଚର ଆସିଲା 2022 ମନ୍ଥ ଅଫ ଫେବୃଆରୀ ମାସ neither student nor a guardian, nobody complain against the teacher, my lord. And after 9 months, one Arpit Padhi, my lord, written a kindly see, my lord.
Yes.
Arpit Padhi inform kale
Or
school
also assistant teacher of your school, you is also
para
screening,
My lord.
he is screening
My
the
lord.
pornography video to the student at
My
class 9C of
my lord.
yes, to so and so school, hence
Now,
reported the fact. What is
19/2/2022 ରେ କ୍ଲାସ ରେ ଏଇଟା ହେଲା ସେଇଟା ଜୁନ ମାସ ସେ ଇନଫର୍ମ କଲେ ଯେ ସ୍କୁଲ ପ୍ରାଇଭେଟ ନା ନାଇଦର ସେ ଷ୍ଟୁଡେଣ୍ଟ ଅଛନ୍ତି ନା ସେ
who is this Arpit Padi?
ଅର୍ପିତ ବାଡି କେହି ଷ୍ଟୁଡେଣ୍ଟ ନୁହନ୍ତି ଗାର୍ଡିଆନ
Who is he, Arpit Padi?
ସେ କେହି ନାହାନ୍ତି ସେ
Have you identified who is Arpit
No.
Padi?
ଟିଲ୍ଡ
What is this? 4 years.
ଏପର୍ଯ୍ୟନ୍ତ ଫାଇନାଲ ଫର୍ମ ମାଇନର କାଇଣ୍ଡଲି ସେ ସାର୍ଟିଫାଇଡ୍ କପି ଅଫ୍ ଦି ଲୋୟର କୋର୍ଟ ଅର୍ଡର ମାଇନର ପିଟିସନ ଯୋଉଦିନ ମୁଁ ରେଜିଗ୍ନେସନ ଦେଲି ସେଇଦିନ ଆଜ୍ଞା ମତେ ହଉଛି ଏଇ ଏଫଆଇଆର
But
କେସ୍
you have to identify who is the
My
informant. And see, while teaching the
Speak.
online teaching, some pornography came.
ମୁଁ
How will you say that the teacher is responsible for that? In the court proceeding the other day, what happened? You have seen.
କ୍ଲାସ ଚାଲୁଥିଲା ମୋବାଇଲ କ୍ଲାସ ଅନଲାଇନ ଯେତେବେଳେ ଚାଲିଥିଲା ସେଇଟାରେ ଆସିଲା
somebody has hacked it.
ହଁ ସେଇ ସେ ଅର୍ପିତ ବାଡି
But what are you doing? See, this FIR is registered way back in 2022 FIR.
ମାଇନର କାଇଣ୍ଡଲି ସି ଦ ଲୋ ଟ୍ରାଏଲ କୋର୍ଟ ଅର୍ଡର ମାଇନର 19/5/2026 ଅଛି ଫାଇନାଲ ଏଫଏଫ ପାଇଁ ଲାଷ୍ଟ ଅର୍ଡର ମାଇନର 25/11 ଥିଲା 25 କୁ ବର୍ତ୍ତମାନ 19/5/26
This is Thursday. You tell me, otherwise I'll close it.
and delay my lord 9 months
I understand. Let him get it, but investigation is going on. So unless except FIR, you have filed nothing.
କିଛି ନାହିଁ ଆଜ୍ଞା
If you file all these things, you bring it on record.
my lord କାଇଣ୍ଡଲି ସେ ସାର୍ଟିଫାଇଡ୍ କର କିଛି ନାହିଁ ଖାଲି ଲୋୟର କୋର୍ଟରେ ଏଫଆଇଆର ଟା ଅଛି ମୋ ବେଲ୍ ବାଣ୍ଡ ଅଛି
You frame it and keep it in your house. Place it on record. Then some order has to be passed. Unless it is there on record, how will I take cognizance of that?
last
POCSO is there, so that
POCSO 12
Whatever you tell, whether you want to continue with the investigation or you want to close, then I'll close. If you are not able to investigate for 4 years, what is the use of keeping it? Yes. Or you tell me who is the IO, I'll ask him to appear in court. Thursday, if you don't say that what is the stage, then the IO will be present in the court. Yes.
Item 5. Seeing of proceeding, my lord.
Today only I'll pass the order for presence of IO. That's better.
Yes, sir.
Otherwise, nothing will happen. I tell you.
my lord.
Casual things they
Yes,
are taking. Right on. To give the certificate copy. The petitioner has filed this petition seeking quashing of the FIR number so and so, registered on 9/10/2022 for offence alleged committed, alleged to have been committed under section so and so so and so. Then counsel for the petitioner has placed on record. You will see has hands up the certified copy of the proceeding of the trial court, which indicates that since last how many years? 4 years. Since last 4 years, the investigating officer is taking time for filing the report under section 173 KRPC. Letter counsel for the petitioner submits that the petitioner was a lecturer. Lecturer, he has resigned.
Teacher.
Has he resigned or what?
Resigned, already resigned.
He is undergoing the he is facing the ordeal of the investigation process since last 4 years without any fruitful outcome. Taking into account the long delay in investigation of the present case, I feel it appropriate to, and regarding it to the nature of allegation made against the petitioner, I feel it appropriate to direct the investigating officer of so case to present in the court through VC mode on Thursday.
15th Miller.
15. Let him come. Let him see what exactly. Yes. Order of the present order be communicated to the which police station? Huh? I think through the state council. Yes. Yes.
Item 5, may I please, Lord? On passing of proceeding, my Lord, FIR was lodged against 100% that the present petitioner while working Anganwadi worker, my Lord, they protested in the front gate of the collector office, my Lord. But charge sheet submitted against the present 6 persons, 5 persons ladies, my Lord, and that is all are available on 7 criminal law amendments. That is no allegation, absolutely there is no on pick and choose basis. They
Bailable offences will be quashed.
no, the only pick and choose basis they are named present petitioner 6%.
You are
And-
Tufan.
Yes.
You are Tufan. Let us see the charge sheet.
Yes,
What are they?
unnecessary.
Yes.
Page 11 is the
Yes. Come to the charge.
F and charge sheet.
31. Page 31. Read.
Yes. Allegation that 100 other Anganwadi worker came in front of the collector gate and sit in front of the gate. Myself with other staff discussed with them not to sit
in front of court premises. The accused person brutally assaulted him. Then he became unconscious and breathless, and luckily also. Where are the 161 statements? Do you have?
No,
Charge sheet is filed, no statement. So the statements. This is incomplete charge sheet.
statement
Tell
when
me, obviously, from the statement only will come to know the witnesses, informant statement. Nothing is there.
information is
The
the
petitioner seeks a 1 week time to place on record the statement of the witnesses and informant
161.
recorded under section 161 CRPC. Release the matter after 1 week. Yes.
item 6.
Item 6, I may be permitted, Millers. On the last
Yes.
occasion, the state was directed to obtain the case diary, Millers.
Yes. Do you have the case diary, sir? The request of the council is granted time to obtain case diary. Yes. Got the case diary. Yes.
My lords, in
Ready?
this, in the, my
Are
lords,
you ready?
order,
Yes.
order framing charge dated 21/1/2023 at page 13 is under challenge, Millers. On the ground that the ingredients of the offences 420, 468, 471 is not made out, Millers. Knowledge incident took place without the knowledge of the petitioner, no mens rea is involved, Millers. All the case is that, Millers, some persons, Millers, 3 accused persons named in the affair, they got themselves employed, Millers, as junior teacher contractual, and subsequently the documents were found to be forged ones, Millers.
420, 468, 471.
My
That's
lord.
the proud document regarding the BEd certificate from the Guwahati University. That subsequently the concerned university, when they are sent to the university to the verification of the document, they are sending that there no such person has been passed out. On that basis, we said a question.
Yes.
My
Yes,
lords,
Mr.
Millers, these persons, Millers, they applied in the proper format, Millers. They went to the exam and the subsequently it
But
was
the investigation reveals that it was verified from the concerned university, and they say that these are the false documents which you have used it for, in the format in which you have filed. The
But-
documents are false.
Lordship, that is true,
That has
Millers.
to be that you have to face the trial and establish it.
But we had no occasion to know whether the documents were
So
supplied.
those are the factual thing which has to be adduced on record by way of evidence. We can't presume today that you had no intention. Who knows
Lordship,
whether you had intention or not?
that is true, Millers. One
How
thing,
come
Millers,
the charge sheet will Moreover, you see, the charge has been framed. You have to file a revision against this.
Your Lordship, your Lordship,
The letter of university is there.
and your Lordship, rightly your Lordship pointed out, my lords, revision may be allowed to be filed for the session judge. my
Okay,
lord.
I am disposing now. Let a counsel for the
Yes,
petitioner. The present petitioner has challenged the order dated so and so, passed by learned SDJM Paralakimundi, whereby the charges under section 420, 468, 471 IPC has been framed against the petitioner. Let a counsel for the petitioner fairly submits that he would be a revision is maintainable against such order, and she seeks permission to leave to withdraw the same, or reserving his right to file revision petition. The prayer reserves merit, the same is allowed with liberty as prayer.
And my lords, that delay part may be considered liberally, my lords, because
So you move for section 14 benefit you will get. Yes.
Item 7.
Yes. 7. What is this? None appears. In the interest of justice, adjourn to next week. Yes.
Item 8.
May I please, Lordship?
Yes.
May I please, Lordship, this petition is filed seeking direction to set aside the impeached order in a revisional court.
What is this order 17?
Lordship, which involved the seizure of a vehicle under section 56 of Orissa Forest Act, Lordship. Lordship, in a revisional order, the revision petition was filed by the DFO, Lordship, whereas he was not a party to the original case, Lordship, in forest case. The range officer was seized the vehicle since 17th of September 2020, Lordships. And till today, Lordships, no final report or no any charge sheet has been filed before the land session court, Lordships. The vehicle is still kept in the custody, Lordship. Lordship, no confiscation proceeding also initiated by the prosecution, Lordships. Third time, Lordship, the Honorable JMFC Contamal has been sent notice to the prosecution, but the prosecution never filed any confiscation detail, Lordships.
No, what the magistrate did, you moved an application under 457.
Lordship, pass an order for
And
release of the vehicle.
the magistrate has allowed it.
Yes, Lordship, allowed it, Lordship.
And the revision preferred by the state is allowed.
Lordship, set aside
Reverse
the-
not. Reverse it.
The confiscation proceeding under the Forest Act is going on.
No, Lordship.
The confiscation matter.
Notice has been issued or not?
Third time notice has been issued by the
state. It is granted 10 days time, 15 instruction of the case. It will counsel for the state specifically instruct whether the confiscation proceeding is pending against the vehicle and for which the release of the application has been filed. Yes. Confiscation proceeding is pending.
Yes.
You have the detail of that.
I didn't have detail, but the rejection order that shows that.
No. See, last order, 4/12/2025, coordinated bench order, you are supposed to get instruction disclosing the detail of confiscation proceeding if at all pending against the vehicle in subject.
No.
Persons to the order dated 4/12/2025, then State Council could not obtain instruction ascertaining the pendency of the confiscation proceeding. Confiscation proceeding. Hence, he seeks 1 more week time, and the same is allowed. Please the matter after 1 week. After what? After 1 week, next week. Okay.
All right,
Yes.
Lordship.
Yes. Next.
Item 9.
Petitioner file an application for quashing of entire criminal proceeding as well as FIR.
What is the stage? The investigation
Yes.
is over.
My lord,
490 Act.
on the ground of compromise, my lord.
Where are the accused? Bring them.
My lord, today, my lord, both are present, my lord, husband and wife, my lord. Informant.
No. See, who all are the accused? How many accused are there?
Accused, my lord, 6, my lord. 1, my lord, husband. 2, my lord, sister-in-law. 3, mother-in-law. 4, father-in-law. 5 sister-in-law, 6
Okay.
sister-in-law.
And who is the informant?
Informant, my lord, two, my lord, wife, my lord,
Wife.
Rasmita Barala.
Rasmita Baral. Where is Rasmita Baral? You come.
Here, my lord, joint affidavit was filed, and London State Council was to obtain instruction regarding that joint affidavit.
What
Last
is
order.
the
Quashing of proceeding on the ground of compromise.
I have got a OP2.
what are the offenses?
Offenses, minor offenses, my lord, 296, 115 2, 118 1, 351 2, 35 of PNS. Read with section 3.
Entire BNS is involved. SCST is there.
SCST.
Can it be quashed?
Yes, ma'am. Number of. SCST.
Can it be a threshold? It can be quashed FIR. Do you have
Yes,
any
ma'am.
judgment to that?
I will.
Get that judgment, those judgments. Huh? Just check it up. You have to get instruction. You are supposed to get instruction. You have not got the instruction. Joint affidavit we filed before the informant continued that equivalent is injured. Contest recorded joint affidavit. So copy of affidavit has already been served on the request. Here you are supposed to verify the authenticity of the joint
Yes.
affidavit filed by the parties. Have you done it?
No, I will not send the letter, but.
So I'll tell you, if in this kind of matter, if the settlement has already been done, if you delay, they'll back out and it will be further complicated.
Yeah.
So do it.
Well.
Thursday? Okay, Thursday. We'll close it if they've settled. Why unnecessary burden right now? Pursuant to the order dated 9/12/2025, the verification of the authenticity of joint affidavit filed by the parties has not yet been done by the state council, and she seeks an adjournment. Release the matter Friday. Release the matter on Friday. Okay, Friday. Do it. Yes.
Item 11.
My lord, behalf of Mr. Patnaik, my lord, kindly take up on next week, my lord.
Next week. On
Oblige,
request
madam.
next. Generally, you don't ask for adjournment.
My
Generally, you don't ask. Why did you argue?
Millers, last order, your lordship directed to call for the CD Millers. CD has not, it's a Koraput.
In any case, he is asking for adjournment. Yes.
Madam.
Okay. Next.
Item 12.
May I please, ma'am?
Yes, sir.
And here the alleged offences are under section 331(4), 75, 296, 251, and thereafter, my lord, in the meantime, charge sheet has been submitted, and the present petition has also been
You are challenging the cognizance order.
again
Yes.
extended the benefit of earlier 42, now 3 so, my lord, of the 35 of the BNS.
Yes.
So one thing has, my lord, constrained me to approach this honorable court because he is on bail, so far police bail is concerned. But because of the fact that the offence under section 331, subclause 4, prescribed a maximum punishment of 14 years, 1-4. That's why the learned court is not taking up on this particular case and not inclined.
331.
331, 4 ta. 1, 2, 3, 4 is there, but see to 4. There was that house lurking house trespass in the dead hour of the night. So the maximum period of is 14 years. But here is no such allegation of that is there. So if that will go, my purpose will solve, my lord. Or my lord will incline to pass an order to the extent as because of the fact that he was on in my lord bail given by the concerned police, it will be continue. It will let go for anything. My lord.
So you are seeking quashing of cognizance or bail?
No, quashing of cognizance obviously, but the purpose is because no, but so far,
indirectly you are asking for bail.
But that is my purpose.
Indirectly you are asking for bail.
No, not exactly bail. I am on police bail. Admittedly, I am police bail.
What is the stage?
Well, so it's
If he is in police bail, let him continue. Cognizance has been taken.
Yes.
yes.
You seek instruction, tell me Thursday.
Yes, Thursday.
Thursday. You make a statement. See, already he is on bail.
Yes.
And in any case, he has to move application and this bail will be allowed. Cognizance is, let him continue with that and let him face.
Cognizance already been taken.
Cognizance has already been taken.
Yes.
He will go and participate in the trial. We will record that. And the police bail should continue. That's all.
That's
Because the allegations are there. Otherwise, unnecessary this petition.
Pending.
Friday.
Friday.
Item 13, may I please, Your Lord, sir?
Yes.
My lord. My lord,
Yes.
offense under section, my lord, 498A, my lord.
Yes.
My lord. My lord, kindly have a glance. The page number, my lord.
Who are you? Husband?
My lord, I'm
Husband and
innocent husband, my lord.
Innocent husband.
husbands are innocent.
My lord.
Yeah. What about the other accused? They are not
My
innocent.
lord, in-laws, my lord. They are
Not innocent.
they are also innocent, my lord. My lord. My lord, kindly have a glance the page number 30, my lord.
Yes.
My lord, the my lord, wife.
Let me issue notice.
My lord.
Let her come.
My lord.
Matrimonial dispute something.
My lord. My
Yes.
lord. My
I
lord.
issue notice to opposite partner. Yes. So accept notice for this case.
Oblige, my lord.
Yes. Item 14.
You may not let it
Yes,
come
sir.
after a week. Some more instructions on this matter.
You need next week?
Next week.
Okay. 1 week of one request.
Wait, interim order, no, interim order.
Interim order to continue.
Wait.
Is there an interim order?
Yes, sir.
There is an interim.
Interim order to continue.
Grateful.
Item 15.
15 May, please, Your Lord.
Yes, sir.
Also, kindly period the last order, that is, my lord, 11th December 2025. The
Yes.
case date was called for money.
Yes, there has not been come, Millers.
Let us come. Pursuant to the order dated 11/12/2025, the case diary could not be obtained by the state council and the one week there. Please the matter after 1 week. Yes.
The interim order is there.
Interim order to continue.
Keeping it, your lordship.
Next week? Yes. Yes. Item 16. Okay. 16 adjourned. None appears. 17. Item 17.
20.
Yes.
The allegation is, my lord, 420. Prime allegation is 420, my lord. Because regarding what land sale. Now, the present petitioner was only the facilitator, and the allegation against him is he has taken 1 lakh by check. Now, there were 2 other persons involved.
What is the
I'll tell you.
price of the land?
Huh?
Price of the land which was fixed.
Yes. And then there appeared to be some dispute regarding the ownership and all that. Now, 24 lakhs was paid. 14 lakhs has already been returned. 2 persons thereafter took 24 lakhs. 1 person took 14 lakhs, 1 person took 10 lakhs. I being the facilitator, present petitioner, 1 lakh by check. That's all. That is his entire involvement is 1 lakh. Now 14 lakhs has already been returned. 10 lakhs out of 10 lakhs, probably 4 lakhs has already been returned. Another 6 lakhs is being in the process of being returned. My 1 lakh, I will return that 1 lakh. I'll deposit in the court.
What is there
proceedings.
I'll send it to mediation, let him
Lordship.
deposit the money. And
Informant is the party, Lordship, let.
I'll issue notice to informant. Let him deposit whatever he's saying. I am sending to mediation.
Lordship,
Why?
467 and 468 is there.
These are pure and simple civil.
Can be sorted out. Can
be sorted out.
Commercial transaction.
I deposit 1 lakh as your lordship desires by the.
Let the issue notice and then
In the
if
informant I
informant
deposit.
appear, then he will deposit.
The petitioner has, what are you seeking here?
I'm questioning.
Petitioner is seeking
Question of
the
proceeding.
entire criminal prosecution arising out of EOW Bhubaneswar PS case number 8 of 2023, various grounds. Mr. Pali, the senior counsel appearing for the petitioner at the outset submits that the disputed amount alleged to have been paid to the present petitioner is about 1 lakh rupees.
1 lakh. 1 lakh by check.
1 lakh
By check. I'll deposit that.
paid, by check. And without prejudice to his case, to deposit the same before this court, at this court. And he further submits that keeping in view the nature of offences, there is all scope that the matter could be settled through mediation as well. Regarding head to the statement made by Mr. Palit.
On instructions, I'm submitting.
On instruction, obviously on instruction, so and so. You give your name, instructing counsel name also.
Instructing
Because you don't
counsel.
have Vakalatnama.
Sanjay Narayan, sir.
Vakalatnama is there, I'm inclined to refer the matter to High Court Mediation Center. The coordinator of Mediation Center is directed to issue notice to the issue notice to the informant. Issue notice to the informant after exploring the possibility of a settlement, file a report. In the meantime, proceeding with so and so.
And my deposit may be accepted by the registry.
Deposit registry to accept the deposit to be made by the petitioner and to be invested in the short-term fixed deposit. Interest bearing.
No course,
Some interest.
no course.
What no course?
Interim order, no course.
Proceeding you want?
No?
Stay of the proceeding.
Mediation.
No coercive action.
What, you have been arrested?
Then-
What kind of?
No. There's already an interim order. Let same interim order will continue.
There is no entry model.
There is no entry model.
There is no entry model.
But
First
in
time.
the meantime, if I'm arrested.
No,
mediation.
you are not on bail and
No, I'm not.
no course. No course.
Ma-
See, he'll go and participate in the mediation.
Yes, mediation, your lordship.
Is already
To the
there.
mediation, there is no need of course of action.
Therefore, I am just passing a
Great.
procedure. Under the threat, why should he go? He should go with an open mind so that he
That
pay
apprehension will always be
under
there.
the threat, why should he be there?
Great.
Release the matter up to give a date.
Urgent copy.
Yes.
Item 18.
My lord, I'm in the virtual court, my lord. I'm a please.
Yes.
Listen for passing of the affair, my lord.
Yes.
The last one, it was directed to obtain instruction and case diary to the.
Have you got?
Lord,
Lordship, I have got paid case diary final form has been filed, my lords, 30/12/2020, insufficient of evidence. Yes, submitted final for under 170.
They have filed a final form saying that there is no evidence.
Yes,
So
my
let
lord.
him pursue their,
Huh?
let him pursue their final form has been filed.
You withdraw it. Huh? Final form has already been filed.
Yes, ma'am.
Pursuant to the order dated 18/12/2025, the State Council has obtained instruction. As per the, you do have oral instruction or written?
No, written it.
The so-and-so.
Lordship.
Yes, please on record the instruction. Please on record the instruction. No, this is final form only.
Yes, last page, my lords. Final form.
Obtain instruction and submits that in the present case, after investigation, final form has been filed stating that there is no case made out against the petitioner. The copy of the final form is placed on record. Placed on record in view of information development, the petitioner, the present petition is disposed of. Disposed. Okay, please.
My lord, the instruction may be kept in records, my lord.
Yes, I have taken it. Yes. Item 19.
Development.
May I please, Your Lord? My Lordship, challenging the order dated 26/9/24, 21/10/24.
Relating to 138 proceeding, in one occasion, once eventually the learned trial court was directed to expedite the 138 proceeding. Despite that, Your Lordship, in the meantime, this is the four occasion.
Who are you? You are
I'm
the
complainant
informant.
report- I'm the other side.
Oh, yeah, sorry, complainant.
Yes, Your Lordship, let it come along with connected matters are there, three other matters to disposed of. And in one of the matter, Lordship directed to expedite the.
What is the check amount?
5 lakhs.
5 lakhs. What do you want?
I am.
In their case, against rejection of 148, the 20% was directed to, against, that was rejected.
What are the other three matters? Give the details.
One is against cognizance, the other is against.
Give all the three.
Yes, I'm giving number.
Thursday. 50, all the three matters, 50. We'll dispose of all the three matters. On that
No,
day.
those matters are disposed for the purpose of that.
Oh, already been disposed of.
They already
Already disposed of for the purpose of the paper. And one of the matter Lordship.
So what do you want here then?
My Lord, in 23rd/8/24, we just want that the complainant should produce the bank account for verification. That I am saying that I have already paid the interest along with the principal amount, my Lordship. Only we have approached to this honorable court on 23/8/24. This honorable court directed to raise those points in the trial court. The trial court has not considered the same, my Lordship. Now kindly have a glance to page number 44.
So that let the connected matter come along with this.
Let us see what he is exactly saying. Yes. 44, yes.
Page 44, order dated 23/9/24. Here, the advocate of the accused filed certified copy of the order dated of the Honorable High Court of Orissa, CLNC number 2930. Learned counsel, next part. Learned counsel for the petitioner seeks to withdraw the petition and the liberty to raise all the points before the court below at an appropriate state. Prayer is allowed. The advocate of the accused person files a petition praying to direct the complaint to file his account.
Read next order, 26.
My Lord, then page number 45, my Lord. So kindly have a glance. Order 26/9/24. My Lord, last para. Having heard both the parties, this court is of the view that the transaction which might have been reflected in the account of the complainant must be available in the account of the accused. If at all there is any payment of the by the accused to the complainant as full payment, that must have been available in the account statement of the accused. Further, as the advocate of the accused has stated that he has already filed the account statement of the accused, so it is not necessary to direct the complainant to file his account statement. Therefore, I am not inclined to allow the petition of the accused, and the petition stands rejected.
According to you, you have paid the
Yes, my Lordship.
past and 143 capital A.
Yes, my Lordship.
143 capital A. And he said that you have not paid. What is the proof that you have paid? You paid by RTGS or paid by check? By what? What is the mode of payment?
By check, and also some amount in cash also.
You show your account.
Yes, my
Whether
Lordship.
the check issued in favor of the complainant has been encased or not. Show me that and finish it up. Why are you insisting for his account to be seen? You show your account.
Yes, my Lord.
That you had issued this much of check, which has been encased. That's what the trial court appears to be saying.
No, I have.
See, your case is under 143A, capital A. The order passed by the trial court to deposit the money. You have deposited. You have given to him. He is declining that. He says that you have not paid. This is the dispute. Show me in what mode you have paid.
My Lord, kindly have a glance to page number 41.
41, huh?
Yes, my Lord. Sir.
Yes.
Payment by Gaurav Agarwal to Anil Agarwal. This is the amount which I paid and dated, and by what, like by check or amount by case. I mentioned everything, my Lord. Sir.
Yes.
And in 42, on the last payment that is made on 17/2/2022, 3 lakhs rupees.
This is towards the direction under 143 capital A.
No, that direction for 20% deposit of the total amount, that is 5 lakhs, that has not been deposited yet, my lord.
That you deposit. See, whether you have paid towards the check amount, whether you have paid or not, that is a matter to be tried. You can't move an application, give the accountant, no, that will not happen. That will not happen. All these things has to be proved on record. You can summon his banker as a defense.
I am ready to pay the amount, but only thing I am praying before this court is to just direct the court to consider his account also, because I have given my.
At the final stage, when the matter will be taken up for final disposal, everything will be taken care of. Why are you in between interjecting, moving application after application?
Your Lordship, see the page 33, prayer portion, my lord.
33, yes.
Yes, the prayer, Your Lordship, see. They have challenged 3 different orders, 26-9, 21-10, and 16-9.
Yes, my lord.
That multiple prayer.
It's all right. Young man is doing. Yes.
16 and 2025, we have approached the additional session judge Kontavanji for criminal revision. At that point also, they have not considered to verify the complainant's account.
This will be kept open to be urged at the final stage.
Yes.
Let him. Yes. What do you think?
Okay, my lord, so I will deposit the 20% of that amount.
You deposit that 20%, 143 capital A, 5 lakhs, huh? You deposit that.
5 lakhs, 20% is 1 lakh
the
rupees.
point which you are urging, I will keep it open to be urged at the final stage.
Okay.
Okay. Right.
And one more thing, Your Lordship, see the complaint case of the 2022. Some player, the other, he has approached 4 to 5 times.
It's all
And
right.
the matter yet to.
Now there is an order already.
Yes.
You said there is an already there is an order for
23/8/2024.
Okay.
On a trial court was directed to expedite.
By which order the trial court asked you to deposit 5 lakhs? Order dated? Order dated?
5 lakh, 1 lakh.
1 lakh rupees. 5 lakhs of 20%, 20% of 5 lakh, that is 1 lakh rupees.
1 lakh. Which is that order?
21. 21, 10, 21.
21?
10, 20, 24.
Where is that?
Page 46.
46.
Yes, my lord.
Last para.
Last para.
21-10.
The accused person is directed to pay the interim compensation amounting to.
For the petition submit that the complainant has filed the case of relation of total. 143. So take amount is 5 lakhs.
5 lakhs.
Well, petitioner is agreed by the order dated 21/10/2024, whereby the trial court directed the petitioner to deposit 20% of the check amount under section 143 capital A of NI Act. Counsel for the petitioner, oblique accused, moved an application seeking a direction to the complainant to place on record the account statement of the complainant, which has also been turned down by the trial court by the order dated 26/9/2024. The petitioner is also agreed by the said order. The present petition has been filed compositely, challenging the order dated 26/9/2024 and 21/10/2024. Counsel for the petitioner fairly submits that he would comply the order dated 21/10/2024 by depositing rupees 1 lakh. 1 lakh, na?
1 lakh.
Deposit 1 lakh being the 20% of the total check amount, as per section 143 capital A of 9. Insofar as the other prayer is concerned, other prayers or seeking direction to the complaint to place on record the account statement is concerned, he would urge this point at the final stage of the case. In view of the statement made by the petitioner, which has been not seriously opposed by the learned counsel for the opposite party, the complainant. I partially allow the present petition, directing the petitioner to deposit 20% of the check amount within a period of 1 week, within a period of 1 week from the date of receipt of 1 week from today, in pursuance to the provision under section 143 of NI Act. And insofar as the other grievances are concerned, the liberty is granted to the petitioner to urge on this point at the final stage of.
No, so kindly observe one thing, that on depositing that 20%, the same shall be released paper of the complainant.
On deposit of the 20% of the check amount, same shall be disbursed to the complainant. Yes.
And one more prayer, also the complaint case of 2000.
His petition you are making.
No, no.
You are,
And complaint case of 2022, learned trial could expedite the, earlier there was direction.
in his petition,
No.
you want relief.
No, because on some player there is 4 occasions, this is his
I would have done it,
application.
young man, I will not do.
No, only my limited period, let it learned court in session over, be directed to expedite the trial.
All right, why are you so apprehensive? It is his petition. He came for some relief, and will go with orders against him.
Matter is the 2022, trial is yet to commence.
Maybe. You move application trial court, before trial court. If it is rejected, you come here. But I will not pass any order.
This will
in your
already
favor in his
directed. You
petition.
will see in CLMC number.
I know you have
Yes.
have a case, but not in this
In
petition.
his petition, how can he fail?
2930-2024, there was direction. Despite that, the learned
There
trial.
is already in the direction.
Learned trial court not proceeding.
Then what to do?
Because
You
on
know.
4 different occasions approach this court.
Then you know what to do. Next.
Obligement.
Item 20.
Item 20.
Pardon, my lord. On behalf of Sunil Kumar Panda, may I seek for an adjournment of 1 week?
Let me announce request. Yes. 21.
Item 21. Last of today record was called for. And one more thing, that may I permit, in the meantime, due to shifting our chamber, I lost my brief. May I permit it to take the copy of the brief by that pen drive, my lord? I will keep this matter next week any day or a week.
Please see matter after 1 week. Yes. 22.
22, my lord. Filed a miss case for quashing of FIR, an entire criminal proceeding. And
What is the stage?
Stage, my lord, investigation.
Going on.
Yes, my lord. And POCSO is there, but here what happened?
3 statement completely cohesive.
But in the FIR, there is no name of the accused person in the FIR, my lord.
Investigation is going on. 164 statement is recorded. That's what he says. Wait. To be premature at this stage.
Yes, my lord, I understand. But in the FIR, no name is there. And FIR was lost.
Name
by-
may not be there, but after investigation, your name crops in. What to do? Withdraw it and file a fresh petition after the charge sheet is filed. I give that liberty.
Yes,
And counsel for the petitioner seeks to withdraw the present petition, reserving his right to approach this court for quashing of approach this court after the charge sheet is filed. Yes. 23.
23 minutes, Belgium matter, On 18/11/2024, my lord, the warrant has been issued, Annex 1. Page 7.
18/11.
18/11.
Yes.
24.
Yes, madam. Okay. See. Page number 18/11/2024. The trial court. You are accused in which FIR? I think it's here.
In TR case number 3, split up case, my lord. The split up case, this is split up case, my lord, that actually, in fact, my lord, is an 87 years old man.
You have not given the particulars. Something has to be written.
Particulars is there for me because
What are the offenses? Nothing.
Offenses 420, offenses of stated, my lord.
Where?
Paragraph 2.
Okay, petitioner.
Right in para 2 of the petition of state.
Okay, petitioner is accused in so case due to default in his default in appearance in the court on 18/11/2024. NBW was issued against him. Then counsel probably wanted to take him for receipt. 500, 1,000, 1,000.
Major lawsuit, please.
1,000. Yes. 24. Yes. 24. No, PS adjourn. Yes. 25. Yes. 25. Yes.
One application I have filed for conversion that may be not test, my lord, because one application, the interlocutor application I have filed for conversion of the 482 to revision, that may be not test because
Not test.
here I have filed, this application I have filed telling the order of cognizance. On the last occasion also.
I number 3988 you will not press.
Lordship, my lord.
Okay. 3988 25 doesn't matter. Okay. Yes.
Here is a case, my lord, that arising out of a matrimonial dispute. Same dispute to initially one FIR has been registered.
You are husband.
I am the husband. FIR has been registered. After examination, my lord, only
I'll
against
issue notice. I'll issue notice. Because matrimonial dispute, let them come.
Lordship, my lord.
Issue notice.
In fact, in same case, twice cognizance has been taken.
Whatever, let them come.
Not the same case, the offenses are different, accused persons are.
Whatever matrimonial dispute, something can be worked out.
Offenses are not different.
You never know.
Offenses are same. They are the in-laws are the parties. Here in GR case, my lord, exonerating all the in-laws, my lord, only charges been submitted against the husband.
Let them come, we'll see.
Lordship,
Something can be worked out, why not?
Lordship, my lord.
Matrimonial dispute can be settled at any time.
Thank you, Lordship.
Yes.
The
26.
IIT also till next date, that may be because on filing of the adjournment
Take
application.
notice, let us see.
Till next date, my lord, that may be because.
No, the problem
because
is
in the-
once I pass the interim order, then you
No,
will be
because in the
finishing.
GR case, my lord, now the trial
Second
is,
opinion.
because in the GR case, now the trial has been commenced.
We'll see.
In the four.
Anything happens, then you come. Mention it. Yes. 26. Bye, please, Lord. 26.
Relating to matrimonial dispute, my lord.
I'll issue notice. Same way. Issue notice.
Plus no course of action, my lord, such a problem.
The SC/ST Act is there.
No, that's right, but.
ST Act is there. Short, 1 week, 1 week. Service through IU.
Let's may I say, let's spread. Plus the similar matter, the in-laws have already notice has been issued. That will also get fixed. Well, this second week of, well, the first week of February. So let's assume that along with that, my lord.
Okay. These channels. Yes. Yes.
Great.
Service through IU, huh?
Well,
service through IU. Yes.
Great.
27. Yes, sir.
What's here? The petitioner is facing a trial under the Special Courts Act. The DA case. The gravamen of the allegations against the petitioner is that he was serving as an executive engineer in a particular organization and some contract works were being undertaken in that organization. The prosecution alleges, my lords, that these contractors, they were actually in name only, and the petitioner himself was doing all those, and the money was being appropriated by him. Now, the vigilance had examined...
Generally, this happens.
No, it doesn't. The vigilance had also examined these people as their prosecution witnesses.
Those so-called
Yes.
contract. Yes.
None of them were tendered in evidence, my lords, as PWs. Now, after the prosecution closed, one of those witnesses, my lords, who was Alif, was summoned by the defense as a witness. So when he tendered evidence as witness, he also produced copy of an assessment order.
Why he has not supported prosecution? Why have you called him?
My lords,
He is not supported. Why have you
the
called him?
entire prosecution case is that I was doing those works in the names of XYZ who were not actually doing those works.
You are one, I mean, the witness which you summoned is one amongst the
One amongst those contractors whom the prosecution did not examine. So my defense plea was that no, they are independent persons who were executing the works and were being paid out of it. So when this contractor who was Alif, he was summoned, he did not support the prosecution story but supported the defense theory. he also produced copy of an assessment order showing that he was assessed to income tax. The prosecution had produced certain savings accounts saying that those accounts were not his, but they had been initiated by me. And I had shown in my income tax returns my income from contractory work at that place, and I had also indicated those savings accounts there. Now, this was marked as an exhibit on behalf of the defense. When the witness was cross-examined by the prosecution, they disputed that, my lords. They disputed that defense document.
Yes.
So therefore, I filed a petition that the ITO may be summoned so that he will produce the entire record showing that during the entire period of the check period, this accused was showing income from his business as a contractor.
311 is turned down.
It was just an application for, yes, basically it's
311.
That has been turned down, which I have challenged here.
Yes, what do you say?
Lordship, kindly see the application, Annexure 3, page
3.
22.
Yes. Yes.
Para 1.
Hmm.
Case was posted today for evidence on the behalf of the defense. DW1 was.
Para 1, you are ready?
Para 1.
Above mentioned the posted for today for evidence on behalf
Cross-examine and discharge. D2 has been examined, cross-examined, discharge. It is also learned that summons issued to DW, Ramesh Barik, could not be served on the address that has been supplied. Hence, short adjournment was given to ascertain the address. DW1 has filed his IT returns. He filed the IT returns for assessment year 2000, 2001, and he having PAN number etiki and assessed to tax as
At ward number 4,
the concerned ITO may be summoned to submit details as to the total period for which DW1 was assessed to income tax. Prayer, then come to your Lord prayer. Pray that Honorable Court gracious place to call the petition and pass appropriate order in summoning ITO to submit the relevant IT returns. It is his document. He has to submit. He has to obtain it under RTA or any other way. If at all he has filed the returns, he has to submit it. Why the ITO will, it's a public document, why the ITO will come?
No, why cannot the ITO be called?
It is the income tax return for DW1.
Yes.
Where is your document?
Who are those documents with me? They were filed by me long back, my lords.
You are chartered accountant? Where is
Both. My counsel is dead, my lords. His firm doesn't exist. Where will I get them? Even I myself don't keep my returns with me, my lords. They are with my...
Which year's return is this?
We had filed the return
2000, 2001.
For the year 2000 and 2001.
2001.
So the check period relates to a previous period also. So since they are disputing it, I said that the IT will appear. He will say that yes, Pankaj Das is assessed to income tax. He will say that Pankaj Das has filed income tax returns showing that he has income from his business of contractory work. How does it affect them? The court is behind me saying that this is an old case. I will not grant you time. Mr. Maharana here says that I will apply under the RTI and I will get these documents from the income tax department. He wants me to be handicapped in my defense. They don't want that the easiest way in which these documents can be made available.
Why ITO? Anyone, a clerk can also bring this.
Yes, whoever can bring.
What is document is concerned?
What is there?
He seeks document only. He is not saying that bring ITO. Through a clerk also it can be.
Yes, it can be.
You can send it through peon also.
That is not the question. The question is the IT returns. He is supposed to file that IT returns.
You are right.
No, I am not supposed to.
Evidence. The document he has to rely unless and until it is disputed.
It has been
disputed. You are also right. He is also right. The problem is what is the trial? Trial is to send it.
Exactly.
That's the whole.
Exactly.
So only then
he will produce. He will produce. I am not interested in that. If some document will throw some light, then let it be there. That's all.
Exactly.
That's the whole idea for the trial.
Exactly.
I am not disputing.
We are always fighting technicality. This happened, that happened. He should produce that. He should produce. Forget about that.
Like document on behalf of the defense.
No.
That
Who is
the
asking
thing
the court
At
to
his
collect?
cost, at his cost.
that
At his cost.
Who is asking the court to
that
collect?
it may be called for.
I am saying the ITO will
At your cost. At your
Yes.
cost.
The income tax department.
Who disputes it?
The income tax department. Let the income department at their cost.
Someone he can
So file the copy of the IT returns.
IT. That's all.
IT returns for the
At your at his
the
cost.
concerned year. On the concerned. There no need of calling the ITO.
ITO need not because he's not going to see who
If that will be supplied by the IT department, then nobody is required to come.
that is your outlook. Let it come on record. The document should come on record.
Man. That
Because
problem.
he says that this is a practical problem.
Man.
Nobody keeps the income tax returns detail.
The impugned order, your lordship, can page 9.
Where is that? Page 9.
Page 9. Considering the rival contention of the parties, it becomes evident that when a person has been assessed under the Income Tax Act,
I know the same.
it is obvious that the assessee can file the IT return. That is the only difference.
I'll record his statement that he doesn't have the copy. He doesn't have the copy, therefore he's
एविडेंस रे आसीची सेमाने डिस्प्यूट कले ए डॉक्यूमेंट टाको मते पचारले वेयर इज योर लॉयर आई हैव स्टेटेड माय लॉयर इज डेड आई हैव स्टेटेड दैट माय हिज ऑफिस इज नो लॉन्गर फंक्शनिंग तापर आया एकटा कहिबा केते दूर जुक्ति जुक्त आया जानि केवल अभ्यासगत आज्ञा ऑब्जेक्शन करिया छडा किछि काम नै
he said that he everything he learned from you.
No, not at all, Miller.
That is true.
Doubtful.
1990, 91 to 1990, 94. Assessment order. Let it be called for first.
But in the prayer he is saying 2000 or something.
No, your the
2001 टा मु देइची
अच्छा 1919 91 90 1991 93 94.
Lordship may see that document which I have filed as annexure 2.
No, what do you want? 1991 1993. There you go. Then I pass that order. Petition is agreed by the order dated 14/11/2025, whereby his application for summoning the IT return for the year 1990 financial year 1990 91 93 94 IT return of DW1 IT return of DW1
namely Pankaj Das.
Pankaj Das for the financial year so.
That I will let it to having PAN
number.
Having it PAN number ଅଛି para 3 ରେ ଅଛି para 3 the application at page 22. PAN number correct देखियो correctly लिखियो no problem. Is it last is G or what?
Yes, G.
G है ना?
Yes. Double A.
That input order page 9 here.
AASPD 6205G. Here G. After arguing for at some length, then counsel for the petitioner, Mr. Panda, has agreed that the prayer made by the petitioner to summon ITO to submit the relevant
ITO Ward 4 Cuttack
Ward 4 Cuttack may not be required. He is interested to bring on record the IT returns of DW1 pertaining to the aforementioned years. In view of the same, the present petition is allowed. The trial court shall summon the pertinent record as mentioned above from the office of ITO
Ward 4
so and so at the cost of the petition.
Objection, your lord.
Whatever cost you.
My objection.
Right money you have to pay or.
Vehemently
opposed.
The
law idea is the see you have to keep that idea.
The law is otherwise, my lord. The law with your lordships have settled is that I am not required to pay.
I know that.
But every time, my lord, they say that I have to pay. I pay. I don't mind paying.
Satan কথা হচ্ছে সে ডকুমেন্টটা মাগি দিলে সরিব
free and fair trial.
That is the reason. That is
trial should be free.
The object is that
trial should be free. You can't.
But they are not interested in that.
Question is 1993 2025.
It's all right. He is now agreeing to pay whatever diet money you have to pay. Some 1,000.
But your lordship observe there is no need of coming up ITO. Recalling the ITO.
Yes.
29
Pardon me, Lord, item 55, there is a mistake in the name of the complainant. 25 number item ରେ complainant ନାଁ ଟା ଟିକେ ଭୁଲି ଯାଇଛି।
କରେକ୍ଟ କରି ନହେଲେ ତ ନୋଟିସ୍ ହେଇପାରିବନି।
ଆଜ୍ଞା ସେଥିଲାଗି ତ-
କରିଦିଅ ତ,
ଆଜ୍ଞା।
Yes. 29.
May I please?
29.
May I please? This is a conviction appeal, my lord. Convicted for 10 years for the 4 of the POSCO Act.
years.
3 years.
3 years.
What is the sentence?
In this case, not a POCSO is there, the notice was issued, but we have not received the report from the.
Okay.
Yes.
Matlab the IO has clearly stated in the cross-examination that the victim and the accused, they were in a love relationship.
No,
My lord, this appellant filed this application, my lord, challenging the order of conviction. Running page, my lord, 65, last portion.
And the engagement was passed on 16/7/2025. Since then, if it is yes.
My lord, I beg pardon to mention.
Appellant, my lord,
this case,
filed this
item
application, my lord.
43,
Filed this application challenging the order of conviction, my lord, which is, my lord, in running page, paragraph 65, last portion, that accordingly the convict Jaga alias Jagannath Das is sentenced to undergo RI for a period of 4 years. And out of 4 years, my lord, this present appellant is in custody more than 2 years. And my lord, the young boy, and my lord, that he was convicted in
Yes,
8
you are
of-
appearing, you are appearing for.
Yes, my notice has already been issued for that reason.
Informant was noticed and appeared. A person with notice. What I beg to say that the copy of the police papers and all that is not available with the informant. Direct.
Take it on pen drive Friday. Call for the custody certificate and antecedents. Okay, because he's 36-year-old. Friday.
Antecedent may be called for.
Antecedent I am calling you. Friday he will get the antecedent and custody certificate, and meanwhile you take it on Friday. I'll decide it, the application.
Right.
Because he is
more than 2 years.
50% of the sentence
Yes, my lord.
already.
The copy of the bail petition has not been solved. Only this.
Keep everything, otherwise unnecessary it will be urgent.
नहीं जो pen drive पे नहीं जीवो जदी
I don't know. You give it. You satisfy him.
ठीक है
Tomorrow you should not ask for time on these grounds.
नहीं है कि मु
bail petition को
हाँ bail petition को
Everything you give, because the important point in your favor is you have already undergone 50% of the sentence.
वर्तमान आया मु मेजर जिनसटा तंग दे देली आया जजमेंट आउट डिपोजिशन कॉपी दे देली
I don't know.
आपन को आगे
All these things I am not going to record.
आप खाली आगे पिटिशन कॉपीटा मु जेरस करके आगे दे दोछ
ठीक है Friday.
हला तो आगे दे दे मेन जिनसटा दे दे
I just come. I just come.
For my lord,
Yes.
here I am praying for bail in appeal bail. Here the maximum punishment is 7 years. 4 of the POSCO Act is there. So the informant who has lost the affair only on the ground that he has.
What is the period undergone?
Almost 1.5 years has undergone. From July is the judgment, and during trial he was bail.
Notice has been issued. What is the service?
Notice issue, but we have not received the report. That we are sending the letter on 11.
Order dated 8/9/2025. Notice to the informant oblique victim was issued. However, the status of service has not yet been obtained by the state council and seeks 1 week time for the same. Leaves the matter up to 1 week. In the meantime, let the state council obtain the custody certificate and antecedent.
I pray interim bail because he is suffering a lot now. Within Berhampur Medical is there.
Where is the interim bail application?
The interim bail I have not filed, my lord. I am filing it.
File the interim bail application.
Tomorrow it will be listed.
File it, mention it, I'll take it up. Give advance copy to him.
All right.
Yes. 45.
My lord, in this case, paperwork not received, my lord.
Okay. This is for what? For hearing, huh? This is for hearing. Okay, least the
45, that is also POXO is there and a notice also sufficient.
Sufficient. Okay, it's all right. Notice was issued to the informant victim. Although notice is sufficient, but none has appeared. The counsel for the appellant report is placed on record. The counsel for the appellant seeks an adjournment to prepare the fees for hearing. Please. Yes. 46. Notice was issued. Yes. What is the position? Service condition.
46 also notice.
Sufficient. Pursuant to the order dated 23/9/2025, notice on the informant of the complainant has already been served. However, none appears for the petitioner. Sorry, none appears for the informant. Yes.
47.
Any. What do you want?
Another date may please.
Okay. Please the matter. Yes.
Order
47.
The cost of 500 rupees is to deposit before the local bar association, my lord. Due to communication gap, that has not deposited. By tomorrow, it will.
Who has imposed?
Pardon?
Okay. By the order dated 11/12/2025, a cost of rupees 500 was imposed on the petitioner, who could not deposit the same due to communication gaps. Therefore, he takes
By tomorrow.
by 1 day. Let the petitioner deposit the cost imposed by the Court of Justice Court by order dated 11/12/2025 by tomorrow. And the least the matter after a week. Yes, up to a week.
48.
Least the appeal up to a week. Yes.
May I please? Cost deposited by today, madam.
Same court. By the order dated 5/1/26, the cost was imposed, not been deposited. Yes.
49.
My lord, out of 7 years, he is in custody about 4 years, 3 months, my lord.
4 years, 3 months.
Yes, my lord.
Yes.
And lordship also kindly see that for the period of time, the 304 compensation 304 part 2 IPC, my lord. 304 part 2 IPC, lordship.
Let us see the.
There are eyewitnesses and the doctor is there. PW 11 is the doctor. I will place the doctor.
No eyewitness, lordship, but only kindly see.
No, 1, 2, 3 are the eyewitnesses.
Let us see the sentence part.
Yes.
Sentence is
7 years, lordship. Although PW.
Page 24, paragraph 30.
undergo rigorous imprisonment for a period of 7 years.
7 years and pay
10,000. Default to undergo imprisonment. 304 part 2.
My lord.
Okay. What are the allegations?
My lord.
What are the allegations?
Allegation, my lord, the being intoxicated, assaulted by means of fist kicks blow, my lord.
Okay.
Killed his father.
Father?
Yes.
Son kills father. But he has already undergone 4 years, 3 months.
No, 3 years, 3 months.
He said 4 years.
Custody since 28/9/2022.
Yes.
So
Get the
22 to
custody-
23,
get
24, 25.
Custody certificate, antecedent and all. Leave the matter next week.
4 years, 3 months, my lord.
Less. There is a doubt now. Yes.
Next month, next week.
Next week. Yes. Yes. 50.
I'm appearing for the opposite party.
Hmm?
I'm appearing for the opposite party. I'm appearing for the opposite party. Final reply with a short reply.
Yes.
He wants to file a reply, your lordship.
Reply.
Yes.
Also entered appearance for opposite party and seeks 1 week time to file reply with the petition. Permission granted, lease matter up to 1 week. Yes.
51.
Your lordship may grant the extend the interim order.
Interim order. Interim order dated.
The last order, my lord.
Acha, interim order dated 6/11/2025 is extended till next date of hearing. Yes. 51.
May I please, lordship? On the last occasion, notice was issued, your lordship, to the informant, and the state was directed to get instructions on this, my lord. This
Yes, sir.
matter has arose from the tripartite agreement, my lord. And as per the mediation report, the entire amount has already been settled and has been paid.
What is the position? AD returned after valid service. Okay. Yeah. Valid service. Valid service. Huh?
The instruction is there. Take a print. Print.
Print.
Yes.
Yes. What is the stage? In which reason is
The
complete.
charge sheet has not yet been filed, Your Lordship.
But
Only the 161.
you have arrived at a
Lordship,
settlement.
well.
Why don't you bring the accused and the informant? I'll quash it.
Lordship, we have already notice has been issued from the last date for the appearance.
You have compromised, then you can bring him.
Lordship, what he is saying right now, the informant saying that 2% interest has to be paid.
Then there is no compromise. Then
That's
either you say compromise, you
no,
don't.
Lordship, as per the agreement, there has been no clause.
That's a different story.
My lord.
You say the matter is settled.
My lord.
Then you both of you come and depose, appear before court. I'll quash it.
Let me take instruction on that, Your Lordship. One more date may be given.
When do you want?
Lordship, after 2 weeks, just 2 weeks may be granted to me.
What 2 weeks? Small matter, bring them on Thursday.
Lordship, I won't be available on the next week. That's the reason I'm asking for the.
No, I am talking about Thursday, this Thursday.
This Thursday, okay, Lordship.
Yes, bring them, I'll quash it.
My lord.
What are the offenses?
The Lordship, the offenses.
420 and all.
420, my lord, cheating only.
In-
Petty matter.
Thursday. Yes. Bring both of them.
My lord.
Yes.
Document.
Let the informant appear and all.
Let the informant
Yeah.
appear. Service is complete, yes. 51 to matter.
This is a lot, but it should notice to the complainant, which I think is a complaint case.
Informant. We appearing in the yes. Yes.
This is your lordship, but it should notice the complainant and complainant as
Notice
it
was
appears.
issued on 22/12/2025.
Yes. Service position.
Notice is supposed to be certain sufficient because noting says that observer number 2 received notice after valid service. Lordship may
There is a tracking report also. Just check.
Delivered only
Sure.
31.
Delivered.
I think Lordship may have
Was
Oh,
delivered 31/12. Maybe one more opportunity.
one more opportunity. Right?
31.
She's right, yes.
Notice was issued by the order dated 22/12/2025. Record reveals that notice is served on the opposite party on 31, huh?
Yes.
31/12.
31/12.
List of justice. Release the matter on next week. Next week we give interim order if any continue. Is there any interim order?
Yes, my lord.
Interim order dated 22/12/2025 shall continue till next date of hearing. Yes. 53.
Yes. For the notice, there is a delay of 95 days.
Huh?
There is a delay of 95 days. No IA has been filed.
Delay condone. Admit, it has
No.
already been admitted or what?
Your Lordship, as per the noting, the appeal has been received by 95 days of delay. No IA has been filed for condemnation of
Jail criminal appeal, na?
jail criminal appeal.
Who has been engaged?
Normal Mandakini Panda is
Mandakini Panda. Where is he?
filed for condemnation.
What will you do with the application? I'll condone the delay and admit.
Without application, that's a
Jail
form.
criminal appeal. Jail criminal appeal. It's normal appeal, I can understand. Jail criminal appeal, you see.
As a
Delay of how many days?
95.
Delay of 95 days pointed out by the SR is condoned. Admit appeal is admitted. Call for the CR. MH Kuri has already been appointed. Call for CR. Release the matter for TCR. Call for TCR and release the matter. Yes, I have admitted after convening. Yes. Next.
54 is same. You know.
Same.
On behalf of Mr. Mishra, my lords. So the legal admission, my lord, delay 198 days.
On the oral prayer made by the MH Kuri, the delay of so day in filing the appeal is condoned. Admit the appeal. Call for TCR. Release the matter. Release the appeal for file release. Yes.
Hearing matter, sorry. Hearing matter, sorry.
54. Yes. Appeal 24. Yes. Call.
55. 55.
55. All these 5 matters are for hearing. Anybody is ready?
2 adjourned, 56 and 58 adjourned.
56, 50. And
56 and appearing for the informant.
which one?
56.
It is urgent, already urgent. Yes.
Appearance were able.
Yes.
And they had to file the surrender certificate. They were able.
Let them do the urgent. Any other matter? Any
55, 57, 59, 60.
59.
59.
Ready?
P25 is the offense level, conviction.
Yes.
3 years conviction. He is inside the custody for 4 months during trial. And thereafter, my lord, and the present situation is he is now suffering from paralysis.
Paralysis.
If your lordship will direct, I will produce the medical document.
Why should I direct you? If you have, see, show me the evidence if it's a case of acquittal or 325. Who is the victim? PW?
PW, victim is PW2, my lord.
Victim PW2. Let us see. Injured, huh?
Injured, my lord.
What is your name?
My name? My name is my lord Hari Kshatriya. Sole accused, my lord.
Is okay. My wife had gone to take work. Assaulted me by means of a spade on my head, causing injury. I fell down.
Though the charge has been framed under section 307 with other offences, but the learned trial court.
Who is doctor?
Doctor is my lord PW 16, my lord.
16.
One cut injury size.
Cut injury size.
Over the head above the parietal bone region, slap, which is grievous in nature and may be caused.
CT scan. Fracture.
CT scan.
Parietal bone. Injured was referred to bush injury.
Independent witness 4 and 5.
What is the weapon of offense?
Weapons.
Huh?
That is also not clear, my lord.
No, just see.
One is
the victim says spade.
spade. Another is
and PW 16, para 2, just see.
PWC page 27, you lord.
PW 16, para 2.
Page 2.
I was sent a with X for opinion. Description of
so that weapon of offense is not clear, my lord.
It is whether it is X.
And another thing is, my lord, PW 4 and 5, who are the eyewitness to the independent eyewitness to the occurrence, they have not supported injured.
PW?
2.
Yes, I read that. Who all are the witnesses?
PW 4 and 5 is the independent eyewitnesses. PW 4 and 5.
Let us see 4.
They have not supported the prosecution page, that running page 20, your lordship.
They have not supported.
They have not supported.
PW 4 and 5 not supported. But PW 2's
2 is the injured.
Corroborates with 16.
And so far as the weapon of weapons, that has not been clear. One is saying Lafa and another is saying axe.
So the peak access something different.
Any spade?
An axe.
Kind of, no. See, but he says
and another fact is
that is recovered.
That has been not been produced before the learned trial court.
What is recovered? 18.
6.
18, paragraph 10.
Whether that weapon has been produced before the learned trial court, that has not been.
Yes.
Required.
That is required. That is required because since the weapon Madam, please, since the weapon has been, different, statement has been received from the
See,
different.
I'll tell you, you are arguing an appeal,
My lord.
it should be argued like an appeal.
No,
You
no.
are arguing whatever he says, you are answering. You
My-
tell me what are the facts, then he will answer to
Best,
civil answer.
ମୁଁ ଏପର୍ଯ୍ୟନ୍ତ କହିନି ସେ ତାଙ୍କର କହିବେ। So
What is your case basically?
my
You
age-
want to, are you ready for arguing the appeal or not?
No, I am not ready.
Then still come to that point, because we have started hearing of an appeal.
Paperwork has also not supplied.
So you
I have not
because
so,
this is what we find.
I have not so also received the paper.
So take the entire DCR by in a pen drive, then start arguing. Because it appears there is some doubt. The weapon of offense is doubtful. Too many things are there. It may lead to acquittal. If you say he's suffering from paralytic and all, file an application for an interim bail if he's in custody.
No, I am in bail.
Not-
During appeal period also I am in bail.
It will be heard 2025. You get ready. Get ready.
Paperwork may can you supply to both the parties, madam?
Pen drive.
Madam.
Now
Madam.
everything is changed. The system has changed. So forget about paperwork. Yes. And I think according to me, subject to this thing, and the High Court rule has to be amended. This paperwork business has to go. It has become paperless. Take in pen drive everything. These are not classified document. The entire document you can take. Earlier, they were preparing paperwork because hard copies were there. There is a chance of manipulation. Anybody can manipulate. So therefore, limited paperwork was used to be prepared. Now everything is scanned. You can't manipulate anything.
Yes.
So take the entire record. Take the entire record and start arguing. Next. 55. 55. Okay. Requested there. Yes. 7. Yes, madam.
May I please your lordship?
Ready?
My lord, convicted for 2 years on the allegation of 498A, 323, 4 DP Act, my lord.
Husband.
Husband.
Yes.
Earlier allegation against 2 persons, 1 person acquitted for the offense 376.
2% means his friend whoever it is.
My lord. So as my lord husband found wife with this person, then thereafter a month, this FIR has been registered against the husband for the offense. And my lord, there in the meantime, there is also marriage also dissolved. Wife also not entitled anything for the adultery part. Only that
Adultery is proved.
proved.
Okay.
Also, there is evidence of this present who is in accused person in this case. One person is the present appellant, Ajay Kumar Nath. Another one is Pradipta Kumar Bai. He is also acquitted in this case, but the wife have been
But now you are convicted for offense under section
498A as morally, my lord.
month and to pay fine of provision.
Acquitted from all the offences only in 498A 323.
RI for 1 year.
2 years.
23.
2 years for 498A.
No. 492 years.
Okay.
RI for 3 months. No. RI for 2 years. Fine of 10,000 rupees. Okay. 323 and 4 of the provision. If you are ready, we can proceed. Are you ready? Have you read the evidence and all?
I could go through the same for the hearing, my lord.
This is fixed for hearing only.
My lord.
If you are ready, then we can proceed. If you are not ready, you are not confident, then this is an appeal. I think this appeal can be heard.
My lord.
Small appeal. Isn't it? The adultery is proved.
My lord.
And the co-accused has been acquitted.
That is not in here, my lord.
That's right. 376 was one of the charges.
376 accused.
Petitioner is filing the appeal. He has to.
I am just wondering whether the trustworthiness of the evidence of the victim, so-called victim.
In CP proceeding,
She was involved with some person. The husband.
It is a submission, but
No,
it is not record.
that's what
Record is
it
evidence.
is. Maybe.
Yes.
And that, no, what submission she is making may be correct because 376, 498.
Yes.
Three charges are 376, 498. 376 is not believed. 498 is there. So therefore, trustworthiness of this witness is also to be doubted, So that is how I would say.
Marriage is not disputed.
Marriage is not disputed.
Cruelty is also not disputed. 498 cruelty to a married woman. That is established.
No, the cruelty for the demand of dowry is there. Section 4 you have invoked.
Cruelty, that is for section 4 of.
It is maybe out of vengeance
But,
because the husband redundantly.
Minor. That is the case.
So therefore, any allegation.
Demand of dowry is not a sign for.
Husband taken
Or
for
498 is not sign canon, but section 4 is also there. Section 4 is
Section
also.
4, if the demand of dowry is not established in every.
Why don't you prepare, madam?
Minor, minor.
Argue tomorrow is a good case.
Minor.
It is an opportunity for you.
Yes, minor.
Okay.
Minor.
Prepare a note.
Mm.
Let it be there in tomorrow's.
Minor. Minor.
And prepare a note. Which witness has said what? TCR is already there. You take it. Get ready.
Minor.
Okay.
Minor.
Okay.
Sure.
Yes.
Item 60.
May I please, sir?
Yes, sir.
My lord, appellant is on bail, my lord. Some time.
You are seeking for bail? You are seeking for bail?
Already granted.
Already granted.
My lord.
Okay.
What time be given, my lord?
In this case, paperwork has supplied to both the parties. Let the date be fixed. Here can be short matter.
Please, what happened to the old members? There is no matter now. Yes, somebody should be ready to argue because you render me unemployed now. The board is with us. I wanted to do some more.
The password. Item 9, the password.
9.
Compromise. 9, the password.
Okay, if he comes, then bring them to chamber.
Those cases has not been listed, my.
I know the special benches to be. Okay.
57.
57. Tomorrow. Get ready tomorrow. Yes.
Joint activity already filed.
Yes, he is there. Investigation is going on. It is a very preliminary stage. Right. Petitioner. Who has filed the petition?
All, my lord.
All.
Husband, petitioner number 1, my lord. Husband.
Ideally, the other family members should have been there. It's all right.
Yes.
Petitioners have filed the urgent petition seeking quashing of the FIR number so and so, interception so and so. Allegation against the petitioner in the FIR interception is so and so. Investigation is in the preliminary stage. At this stage, the parties have entered into a settlement. Opposite party number 2, who is the informant in the present case, is present in person. And petition number 1, Santosh is
Yes,
petition
Santosh
number
Kumar.
1, the
Santosh
husband
Bhai.
of opposite party number 2, is also present in the court. They are being identified by their respective counsel. They filed their self-attested copies of Aadhaar card to establish their identity, which is taken on record. Both the petitioner number 1 and opposite party number 2 conjointly submits that due to misunderstanding, the FIR was registered and now they have settled their dispute in regarding happily as a married couple. And they have also filed a joint affidavit before this court inter alia stating as under. Joint affidavit dated agitrately though, stating as under. para 3, 4,
3, 4.
3, 4. Para 3 and 4. बंद कर दो कौन प्रॉब्लम थिला हैव यू आस्क्ड नो प्रॉब्लम माइनर डिस्प्यूट किछ प्रॉब्लम होबन ता को किछ प्रॉब्लम करिवन तो की अरे यू आर गवर्नमेंट एम्प्लॉय व्हाई आर यू डूइंग ऑल दिस थिंग यू लूज योर जॉब आल्सो बुझ पाला तो चाकरीटा पळेबो आगो को सिम हैरान करनी ठीक अछि आज इटा क्वास कर दउची किंतु आगो को केयरफुल रहइबो जदि आउ किछि करिवो त चाकरीटा जीवो हां चाकरी जीवो चाकरी गले ना तांको किछ फायदा हो ना तुमको कोन फायदा हो दिना हैरान हो ठीक अछि फैमिली को संभाल के रखियो ठीक अछि regarding get to the nature of allegation made by the opposite party against the petitioner, and this being a matrimonial dispute arising out of a matrimonial discord, and since the parties have settled their dispute and conjointly submitted before this court to close the entire criminal prosecution, and have also filed the affidavit to that effect, I am inclined to allow the petition. Accordingly, FIR number so and so is coerced.
Also others, my lord.
Huh?
Others not appear, my lord, present not to
ठीक है
on behalf of
for all, but you do one thing, you file an
affidavit on behalf of others.
no file an application seeking exemption. That's better. Just now you filed one page application, file because they're old, their parents na
Parents
and
Bhoni or sister-in-law and sister.
The on behalf of petition number 1 to 5, an application 1 to 5, 1 to 6, an application has been moved.
2 to 6.
2 to 6. An application has been moved seeking exemption from appearance before this court. Entirely on the ground that the petition number 2 to 4 are the family member of petitioner number 1. They have been arraigned as an accused since the investigation is at threshold in nascent stage, and the family members are the parents are senior citizen, and the opposite party number, sorry, petitioner number 2 is a lady,
Sister-in-law.
Lady, being lady sister-in-law.
2, 5, 6, sister, my lord.
2, 5, 2, 3, 2, and 5 are 6 are the sisters.
Nine, my lord. 3, 4 hele 3 hele mother-in-law, ma, 3 mother, 4 hoji father.
4 is 4.
Au 2, 5, 6 hele sister.
Likhilu na? Sister. I'm inclined to allow this application and exempt the petitioners from appearing before this court today. And the present petition is also allowed qua the opposite party, sorry, petition number 2 to 6. 2 to 6 also. 2 to 6 also. Okay, move an application right now. One page application saying that mother-in-law and father-in-law, they are senior citizen and they are sisters.
Yes.
Independently, they are married and staying separately. Write down, that's fine. Petition is acting on instruction. This is being the file. One page application files. Okay.